9 a.m. docket.
With that, I will call council forward on case number 125274. I'm going to give the abbreviated version of the caption and say Ross versus Nelson. Council.
It please the court, Patrick Hughes on behalf of the appellants Norman Terry Nelson, Stillwater Swine LLC, Husky Hogs LLC, and NTNLP. The foundational question in this case is, does the body of rights that makes up a highway right-of-way include the right to place a privately owned pipeline in the boundaries of the right-of-way? The amici tell us that Kansas agricultural producers have understood the answer to be yes. In fact, the Supreme Court understood the answer to be yes in 1915 when it wrote in the Murphy case that a person who lays pipelines in the public right-of-way for private purposes should have buried the pipeline in the public right-of-way. To understand why the answer is yes, we have to understand the test that the Kansas Supreme Court has used in the past to determine whether a specific use is within the scope of the rights that the state owns as part of the highway right-of-way.
Let me ask you just as an initial matter, Murphy was a negligence case, right?
That's right.
And so it really didn't address the substantive issue that you're talking about. Is there a case that you can cite that is more directly on point?
Yes. So we start with the proposition that we're looking at a right that was granted by the federal government under the Mining Act of 1866. And the U.S. Supreme Court tells us that that body of rights includes whatever Kansas says that body of rights included. And so in 1904, it came to the Kansas Supreme Court to ask the question, what does that body of rights include? And the Kansas Supreme Court set out a test that began in the McCain case. And this was a telephone case. And the question was whether putting the telephone poles and lines in the right-of-way.
No, I meant you cited Murphy for the gas company, you know, that it would be not a public utility, so a private.
Right.
Is there a case for a private?
There's not a case that arises in the context of it being a private use. The context in which the cases arise are ones where you have public or a quasi-public utility or something like that.
Okay,
but
thank you.
The reasoning of the cases doesn't stem from that. Instead, in McCain, what the court does is it says that we're going to look at the purpose. It says the purpose of the highway is the controlling factor in answering the question of whether the easement contains the rights needed for a telephone line. It said the question of whether an easement was included the rights for a telephone line must be decided by the scope and purposes of the highway, and whether the issue is a means of travel and transportation. So that's the test that the court announces in 1904. In 1905, the question comes up again, this time as to a pipeline. And the pipeline company in the 1905 case comes to the court and says, we have the right to put the pipeline there because the adjoining landowner gave us permission. And the Supreme Court disagrees, agrees that the pipeline company has the right to put the pipeline there, but disagrees that the source of that right is the permission that the pipeline company has. The court writes that—
Well, let me ask you, what right does the public have in a highway easement? It's a non-possessory interest, right?
The public has the right to use that property for all transportation and communication purposes.
That's a non-possessory right.
It is an easement. The extent to which it is possessory, I think, is an open question.
At least our early case law describes it as such.
Right, and we have other case law that suggests in the context, particularly we're looking at railroad rights of way, right? That we have, and there's an exclusive component of that revolves around safety, and we have the same underlying interest with respect to highways as well. And so there is the ability. We have this the concept of an abutter's right of access and taking access, which means that we can exclude from the right of way, we can exclude the adjoining landowner or anybody else by regulation.
once that easement has been created, and it's been described that once, in McCann, I think, when land is once taken for a public use, it is afterward applied to another similar public use, then no additional compensation is due. I think that's a takings question in that case, but isn't it also suggest that that sort of use is consistent with the scope of the easement?
That's exactly what the court's saying, is that whatever we got, whatever's that scope of the
Right.
use, it's not a new taking, or it's, in this case, it was never went to the landowner, but in any case, that's right, because the scope of the easement is for transportation purposes. Any transportation purpose is allowed without it being a new taking, without it intruding on the rights of the adjoining landowner. And because it doesn't intrude on the rights of the adjoining landowner, we have a standing problem, in this case, if the scope of the rights includes the ability to put in a pipeline for transportation purposes. Because if that were done incorrectly, it would be a wrong against the public, not a wrong against the private landowner.
Is
So-
the second, let me ask you that. So if we reasonably interpret, Kansas case law to say that, this highway easement includes, the use directly related to the purpose of transportation, don't our cases also say that it must serve a public purpose?
Well, in a sense, of course, but when I drive my private car on a road, I don't need to pick up hitchhikers. I'm not required to do that. The public purpose is found in the transportation itself. We're transporting product from one location to another. And that transportation that's an inherent public purpose in the right of way. Now, we have additional public purposes that are served here. For example, in McCann, one of the things the court found that it noted is that you're substituting, instead of messengers, that we have 1,000 messengers a day, now we can have the lesser impact on our roads of telephone lines. Similarly, rather than having 1,000 tanker trucks a year hauling the water and effluent that we have in this case, we have a pipeline that doesn't then require the maintenance and the traffic and the safety hazards that come from all that truck traffic. So there are public purposes in the very exercise of the public right by an individual in the public is a public purpose. We found this in the hunting case, where hunting, of course, is a public right, but even though, and therefore a public purpose, even though it's exercised by an individual.
Okay, so, what you're saying, I see what you're saying. But do you have a case that you can give us in Kansas that says that the public purpose is inherently found in transportation itself, which is what I wrote down that you said?
So what we find, I don't have a case that has those words, no. But what we have is the McCann case that tells us that we're looking at the purpose. And what is the purpose of the easement? It's for transportation and communication. It tells us that that's the
McCain
test.
or McCann?
I'm sorry, McCann.
Okay, so
McCann.
McCann though was a telephone pole.
That's true, but the reasoning that the court uses isn't, it's a telephone pole. What the court says is, we're going to use the test of what matters is this in accordance with the purpose of transportation or communication. That's the test that
Well,
they're
that's the
using.
first part of it, but in, telephone poles, those are public utilities, they're not for profit, for private profit.
That's true, and neither is my car. And so, there's no statute that gives me the right to use the road for my car.
But-
Instead, there are statutes that regulate how that right is used.
But me driving my car, I don't make a profit off of that.
Well, I might operate it from my business, and I might be hauling, and certainly if I have a tanker truck that I'm hauling my water and my effluent with,
Yeah.
I'm using it in my business. And that is as a sufficient public purpose because it is the exercise of a public right by a member of the public. That's why we have public rights, is for the individuals in the public. And so we can look at section 20 of the Kansas Bill of Rights, and we see that the rights are reserved to the people. So, and we see this carried out then in the case that deals with ice on the Kansas River. The Kansas Supreme Court faces the question of who gets to take it. And the Kansas Supreme Court says that until the legislature creates some rules about it, it's a public right, and so anybody can take it. It's inherent, the use of that ice for the public use is inherent in every individual.
Which leads me to the question of where would we draw the line?
But you don't, the regular
So
legislature.
if 100 people wanted to do what your client did,
Yes, if there's a problem, then this is a regulatory problem. It's a traffic problem. The nature of traffic is you have more demand than you have capacity to service that demand. And the legislature's role then, just as ice on the Kansas River, if it's a problem, to create the regulatory environment to distribute those rights or allocate those rights among the competing interests.
But you're
Can I
valid.
Oh, go ahead if you have a question on this issue. I do have a couple questions on the nuisance issue.
You're analogizing your truck to the road, correct? Or you're analogizing the pipe to a truck on the road,
Yes,
not the road.
that is correct. The pipe is a vehicle for the transportation of the commodity inside the vehicle.
But if that analogy is correct, then aren't you saying it's okay if you're the only truck that's allowed on the road?
I'm saying the legislature can decide how to deal with traffic. It's certainly true that when there is a competition, well, again, the ice case, what the result of that is only one person gets to take the ice. And the Kansas Supreme Court says, if the legislature wants to change that, they can. And that is a legislative decision because that is a potential problem. If we have more demand than we have space in the right of way, then something's going to need to be done to allocate those rights. And what's to be done is not to say, well, as a matter of law, it's not included within that body of rights. The question is, how do we regulate those public rights? How do we regulate the right for hunting? Not everybody can hunt because there's not enough wildlife. We regulate that at the legislative level. We don't say because there's not enough for everybody to use that public right, nobody can. And so it becomes a question of regulation. But what we're looking at today is the question of, is it within the scope of the rights that were acquired from the federal government when the federal government made that gift to the people of Kansas?
And here, some of that regulation comes through the local permitting process.
Well, no, the local permitting process here is really it's some regulation. It's regulation in the sense of some of the requirements for the pipe itself. It's not a process, though, here where the county commission approves or disapproves. There's no discretion in it. It's really kind of a registration and you meet these standards for the pipeline. And then you're not in violation of our regulations.
And even if they were, would that still be outside the bounds of trespass? It would
Yes,
be
because
something-
then it's not a right that belongs to the adjoining landowner. If I drive my car when it's not registered on the roadway, I don't suddenly commit trespass. Instead, what I've done is violated the public's rights. If I drop a hay bale out of the back of my truck onto the highway while I'm driving, I have not trespassed on the adjoining landowner by doing that. I've impaired the public's rights to travel by doing that. So it's not a trespass case.
So in your view, there's nothing that stops 10 landowners in the area of putting in pipeline on that easement?
Practically there is because there's no
Right.
need, but until that traffic problem becomes a problem, there's nothing that stops that. The legislature can step in or through the county commission, which has home rule power, can step in when and if those kinds of conflicts arise, and by regulation control those conflicts. But it isn't a question of what the scope of the right that the public owns. It's a question of how that body of rights is allowed to be used and how it's regulated.
Okay, if I can move you on to nuisance now. As I read the summary judgment ruling, the district court decided on summary judgment that your clients were not entitled to judgment as a matter of law because the summary judgment evidence didn't establish the compliance with law presumption, which triggers the good agricultural practices presumption, which means then it's not a nuisance. It's presumed not to be a nuisance. Then at trial, that issue's not renewed. And typically we require unless it's just a pure question of fact, that issue to be renewed on summary judgment, given the interlocutory nature of a summary judgment ruling. Am I reading the record correct there? And why, what's your best argument for why this issue is even properly before us?
There are two nuisance issues. One is the Dill case, which would support the argument that there wasn't sufficient evidence, and that's completely separate from the
Yeah,
question we're looking at in the statute.
Yeah, I'm
Right.
focusing on the statutory
Right.
defense.
And as to the statute, the denial of the motion for summary judgment became a final order when the verdict is entered and the judgment is entered based on the verdict. And then once that becomes a final order, the interlocutory orders of the court become appealable. And so we're able to go back to that question that the district court decided on the motion for summary judgment and review that question because that interlocutory order has become final.
But the interlocutory order was simply that there's a fact question.
The interlocutory order went beyond that. It wasn't a fact question. It was it was a legal conclusion. The legal conclusion was that it was because you have a trespass, you cannot use the statute. That was a legal question. It wasn't a factual question in that sense where there's a contested fact. The conclusion was because we've determined that it was a trespass, you didn't follow the law. Because you didn't follow the law, you can't trigger the presumption. So that was entirely a legal analysis, not a factual analysis.
Okay. So you're suggesting that that ruling was essentially purely a legal conclusion.
Right. That's what the court indicates, is that it is the conclusion that there's a trespass that prevents the statute from operating to create this protection.
And there was no indication that you could have brought new evidence at trial to demonstrate compliance with the law?
Well, you couldn't, in the sense of the court has decided as a matter of law. there's a
Enter
trespass.
judgment on the
And so
trespass.
once that judgment is entered, the court is saying it automatically flows from that you cannot possibly establish the application of the statute because the trespass prevents the application of the statute.
So that barred you from asserting that presumption, not necessarily from otherwise proving it was a good agricultural practice, but in terms of that statutory presumption in subsection B.
That's correct. That's correct.
Preston?
Please, the court, Randy Rathbun. I represent Mr. and Mrs. Ross and their entities, and Laura Field and her entity, her trust. I don't want to start out and talk about a case right off the bat because I think the court needs to understand the enormity of what happened in this case. I have to take you back, if I could, to the Monday afternoon, August the 21st of 2017. My client was out doing something that all farmers like to do, going out and checking the field. He comes up over a hill, and as he looks down the hill, there is an excavator tearing out all of his fences and tearing out his trees. And so he drives up and says, "What in the world is going on here?" He calls his county commissioner. The county commissioner arrives. Mr. Nelson arrives about the same time. They say, "Where is your permit?" And Mr. Nelson says, "I don't need a permit. I've done it before. I'll do it again, and you can't stop me." And that's their view of the law. And in this case, we didn't stop him. He went on ahead and finished in spite of the sheriff's orders. So that brings us here today. Now, one thing that's not been discussed, and I think real important, is the statute that back a year before the Beckwith case, which I think is the key case, but a year after the Beckwith case. In 1874, in the Session Laws 111, Section 1, the legislature said all section lines in Norton County will be public highways if 10 freeholders ask for that permission. And so we were dealing here with a public highway that was created by an act of the legislature. Now, the year before that, in the case that controls this whole thing, I believe, Shawnee County had taken property from a man by the name of Mr. Beckwith and didn't want to pay him for it. And this court looked at that issue back in 1874, and that opinion has been cited innumerable times, clear up until I think the last one was in 235 Can in the Southwest Bell versus KCC case. It's been cited innumerable times for when there is a taking of this nature, and I'm not talking about in the city. This is a situation where the legislature took property. This court has said the landowner keeps the fee right up to the road, and the county or whoever maintaining it only gets an easement. That law has been standard law for 140 years. Your Honor, the reason he could not list a case in which a private individual had tried to do this is because there are no cases in which private individuals went out and tried to lay lines like this anywhere.
Just a very basic question to help my ignorance in this area. Are the public highway easements set forth in a kind of meets and bounds kind of a way, such that we could say it extends 75 feet from the edge of the road?
In fact, what happens is the session laws, I believe they say it has to be a reasonable amount of property when they take the property from the landowners. And so there's no specific amount, although the court in Beckwith determined that the set off was reasonable. But I know of no statutory that
So
says.
in other words, with respect to this particular easement, you can't go to the county register of deeds and pull a meets and bounds description of the easement.
This is an act of the legislature saying all section lines are public highways.
And since you started out describing what actually happened, do you know how, what was the distance between the road and the fence and tree line?
I would
Is that in the
say,
record?
it's on the record, but I would say from me to you, Your Honor. So at this,
Let me ask a question. When I was reading through everything, is it that the fee goes right up to, I mean, it includes the road, but what Beckwith says is the owners of real property that include public highways retain fee title and have the right to use that land as long as it doesn't interfere with the use of the road. So it actually includes the highway, but they just can't interfere with it, or?
Your Honor, I've thought about that, and it may be similar to you owe to the middle of the river. I mean, but certainly the private individual, the abutting landowner can't do anything to interfere with traffic up because the laws are playing on that. But Beckwith also says we can't interfere with abutting landowner's grass, trees, whatever he wants to do in that ditch. And this has been good law for 140 years. There are three ways you can do a pipeline.
Didn't mean to interrupt. The flip of Justice Steele's question then in your exchange leaves me confused about whether or not the property owner's title, indicates where the property ends.
I think it clearly says up to the road. That's what the cases say.
But
And it says, and Beckwith specifically says the ditches are the property of, the ditches are fee.
But if you were to look at the deed, would it describe the boundary of the property as the section line?
I
I
can't,
think that's.
I
the
don't
Chief
know.
Justice.
I don't know. I'm sorry about that. There are three ways I think you can lay a line.
Part of the reason that may become important is, does that property owner own underneath the easement?
I don't know. The
Which may
property
be-
owner has all the rights with fee, and of course, all the rights of fee includes the subsurface rights. Because the abutting property owner has a fee interest right up to the road. And he can't do any, in fact, he's probably got a fee interest under the road, but he can't do anything to interfere with travel on the road.
Well, and isn't that sort of accurate with our description of the case law, how it's been described, is the fee owner owns everything, including the road and subsurface, but that they're limited to, they can't use it in a way that interferes with the easement.
I haven't seen anything anywhere that says the abutting landowners own the road as well because they have a fee underneath it? I mean, that's certainly a conclusion that could be drawn, but I'm not aware of
Maybe,
any.
yeah,
cases
maybe
that say
more
that.
legal treatise than case law.
So I see three ways that you can do this. You can do it with consent of adjoining landowner, you can do it with legislation, or you can do it if you're a public utility. Clearly, he was not any of these. This court has cited Beckwith so many times, and in fact, if you look at this, all the people that quarrel with the defendant's argument is all those cases, two AG's opinions, the district court, a unanimous court of appeals, and maybe most importantly, Mr. Hughes himself, when he was testifying about legislation, whose attempt was to set this judgment aside. Mr. Hughes testified in front of the legislature, you know, the trial court is right and the remedy is not in the law. Now, I don't think judicial estoppel probably applies to that because I don't think you meet all the elements of judicial estoppel, but certainly when he's in front of the legislature telling the legislature that the trial court was right and the remedy is with the legislation, I don't know, there should be some estoppel there.
Does the Murphy gas and oil case disrupt your narrative of what the law says? I mean, because it's a private purpose case, right?
I don't see how, because it had nothing to do with transport. I don't see how it does, Your.
Well, why not, when what you described are, you said there's three ways. And Murphy is a fourth way. I mean, it's a private company and the case says for private purposes.
Your Honor, I'm not sure that I understand the purpose in Murphy was for a private purpose.
Would you acknowledge that the court described it as a private purpose?
Your Honor, you're familiar with it, and so I'm probably going to, but
Yeah, I'm just
that-
asking you to
I don't.
account for that decision, or is it just an aberration that we should disapprove?
It's the only, I don't see any cases that have been cited in this that says a private entity for private purposes can lay their line without consent of an abutting landowner. It's
Wasn't the pipe obstructing traffic?
sorry?
The Murphy pipe, wasn't it obstructing traffic? Wasn't that the problem, why it was a negligence case?
Well, I don't think, I didn't notice it. I thought it was a matter of the collision with the pipe.
Yeah, I mean, I don't have the case in front of me, but colloquially, the conclusion was sort of, you should have buried the pipe.
And of course, that whole case is out of context for this, and it didn't deal with the easement and the fee and who owns that. But I certainly think the context is important in this case, Your Honor.
So a private company could have buried the pipe if they'd gotten permission from the landowner to do it, right?
Absolutely. Absolutely. And in fact, that's what's happened over the years. I mean, it's not, people just don't go out and dig up ditches and put pipes down there unless they've got permission or they've talked to the county. In this case, the county had specifically not given a permit. He had not got permission, and his position was, I can do it because I want to do it. And what's to stop the next guy from saying, I can do it because I want to do it? There's nothing. The Association of Counties say this isn't in, when they responded to this legislation that the defendant suggested, they said, we don't want that job. That's not our job. I mean, this is going to be, how many private lines can you put in a ditch that you have no legal interest in and that interferes with my client's fee? I just don't know how you do it without an act from the legislature. So, Your Honor, I want to quickly scoot over to the nuisance issue. To me, it was a Judge Klein case down from Wichita, and I'm a little bit familiar with it. And, you know, in these situations, they were trying to permanently enjoin an operation. And the Supreme Court just said, you know, I think the way to analyze that is there's an adequate remedy at law. And if there's an adequate remedy of law, suing for a nuisance, you can't get permanent injunctive relief. And that's what Dill was doing, permanent injunctive relief. Now, there might be some question about whether that's even good case law after the Right to Farm Act. And I don't know. I cannot see how you distinguish what's happened here on the right to farm situation. What we have here, because, well, a couple of things. As the Court of Appeals noted, they didn't even bring up, they've never argued C2 that this was a reasonable expansion. That's never even been argued. It wasn't argued down below. And so there's never been any argument that this was a reasonable expansion. My client and his family have lived on that property since 1963. They were there long before the situation, and that's the introductory language under the Right to Freedom to Farm Act. They were there making use. The center pivot irrigations weren't put in until the last 20 years or so. And so they've lived there long before the center pivot irrigations. And here is the key, I think, on the freedom to farm. You cannot run that pig operation without a way to dispose of the waste. The center pivots are essential. You can't have an existing pig operation without a way in which you've convinced KDHE that we're going to dispose of all of our waste. So the pipeline was essential to have the hog operation. There's no way around that. And so,
Well, why are we even considering upstream activities in terms of the nuisance? The statute, subsection A, it provides a defense against nuisance for, quote, agricultural activities conducted on farmland. Subsection B, which then gets into the compliance with the law, says if such agricultural activity, referring back to subsection A, activity on the farmland. So why does the statute allow us to even look back in terms of whether or not the activity complies with the law to any conduct that's not strictly on the farm ground?
yeah, I don't know that the statute limits it to that. And I think you have to look back, Your Honor, because the whole thing is run through one. The center pivots are only there to get rid of the manure from the, I mean, obviously they can put water out.
Well, how do we get there under that language that said that I just quoted to you on the farmland? Activities conducted on farmland.
In section A.
Yeah, and then section B says such activities, if conformity with the law is presumed to be a good agricultural practice.
And if you look at the definition of activities, I mean, isn't spraying liquefied pig manure an activity on that farm property?
I agree. It is an activity on the farmland, but the question is whether that activity complied with the law, the spraying on the farmland. And we're just wondering, under that statute, is there an interpretation that allows us to expand our focus to that upstream conduct that gets you to the farm ground?
One, I don't think you have to. And number two, the court's analysis was, when you talk about existing laws, rules, regulations, this court has always said that existing law also includes case law, common law. And in this case, there was common law that said what he was doing was a trespass. And so, I mean, therefore, he's not conducting that activity consistent with good agricultural practices.
Let me ask you a question. So what you have is, from one activity on farmland, and then you have the pipeline that's not on farmland, and then it's going to farmland, right? Okay. And so the question is that the illegal activity seems to be happening in the pipeline and not on the farmland or the farmland.
Well, here's the problem. You can't get to the farmland without the illegal activity. If you, every day when you are running liquefied hog manure down the ditch, that is illegal activity. you can't get to the other activity without having an illegality every day.
What if they drove it on the highway and then pumped it into, or used the pump to get it into the pivot?
Then there's a different issue. Then you have to look at the issue and see whether you're going to qualify for the way they actually sprayed it on my client's property, whether that's good farming practices. But we didn't even need to get to that because there clearly was an illegal activity that was part of this activity. One thing that, look at it this way, if we load up all that hog manure at the end of every day and drive to the property to dispose of it as opposed to running it through the pipeline. But let's say there's a big hole in the side of our truck or in our tanker and it leaks pig manure all the way to the other place where you're disposing of it. That is a trespass, dumping your pig manure on public roads. No one would say the Right to Farm Act allows that. The farmer couldn't say, well, under the Freedom to Farm Act, I can spread this wherever I want because it's not a nuisance. And maybe it isn't a nuisance, but it's certainly a trespass. And you can't find protection in the Freedom to Farm Act there.
Please, the court, I'd like to begin by supplementing an answer that I gave previously to make it more complete. The question dealt with whether I could point to a case in which we were dealing with private rights in the use of the road right-of-way. And I neglected to mention the case that I cited in the brief of Walker versus Armstrong from 1863, in which the court held that all persons had the right to land a ferry boat at the mouth of the public highway without the consent of the owner of the soil until the legislature granted an exclusive franchise for doing that. The underlying principle there being that anyone could use that as an individual here for the landing of a ferry boat. With that said, there are a few comments that I'd like to respond to briefly with respect to the facts of the case. And that would be the tearing out of the fences allegation, the allegation that Terry Nelson said, you can't stop me, the claim that he hadn't gotten permission. I think in all of those things, as you review the factual record, you'll see that that's not a complete description of what it is that happened, and that maybe you may find that is in fact a misleading one. But it doesn't matter to the legal issues that we're dealing with. To the extent that this is a case of first impression, we are of course in exactly the right court to deal with that. And so to the extent that we don't have a case that says specifically you can do this, we come to you to say, should we apply the same rule we've always applied?
So on that point, on that very point, I wanted to dig in a little bit to what you said at the beginning of your rebuttal. I think you were describing case law that relates to rivers and ferries. Is that correct? And then earlier you talked about ice on a river.
Right.
The difference here might be, well, it is a difference and it might matter legally, that when we deal with the public right of way in rivers, we don't have an easement. Whereas with roads, we do. Does that matter?
I think that the rule is that for a navigable river, the water course belongs to the public and the public has the right to use it, but to the center of the river, the landowner owns the fee to the center of the river, much like with the road right of way. And with the road right of way, in answer to the earlier question.
You would agree with me that there's no easement.
There is an easement. It is because that's what the public right is with respect to, it owns both the water and the right to use the area.
How does the easement come into existence? I mean, maybe I'm just dead wrong on this, but when the public takes land for a public highway,
right,
I mean, they obtain an easement.
Well, when the public obtains land for a highway when they want to obtain a right of way, that's what they obtain. Here, there's no question that what they got from the federal government was a right of way, wasn't merely an easement. That's true. And so the question is, the body of rights that were used, were those rights that were conveyed to the plaintiffs' predecessors in interest? Or were those rights that had been conveyed already to the people of Kansas?
I'm just trying to figure out if the application of the river cases is a square 4-leg application, because I don't understand how there's an easement in those cases.
The point of the river case is that we're dealing with a right that belongs to the public at large. And the
It's a
question is,
feature of geography. I mean, that's public waterway law strikes me as quite different from,
but the underlying principle, and the same principle with hunting, is that we have a right that belongs to the public at large. And the question is, who can use that right? And the answer is the individual members of the public. So the question, what it doesn't answer is the question of, is there a distinction between a pipeline, a legal distinction between a pipeline that serves several people or two people and a pipeline that serves one person? And if so, where do we find that legal distinction? What's the basis for saying?
what if I had two pieces of property on opposite sides of a highway separated by a mile? And I was an exotic billionaire and I just wanted to be able to move back and forth. Could I build a tunnel under the highway?
You could not do that because that is a transportation use that has been acquired by the public. And so you couldn't do that.
Why not?
Because that's not within the body of rights that were retained. The body of rights that were retained were everything but the right for transportation purposes. Now, could you
That's
do?
transportation.
Well, I'm sorry. What I meant to say is you could not do that as the owner because you're the owner. You could do that because it's a transportation purpose. You would be using the public right. You wouldn't be using your retained rights as.
Yeah, so the
owner.
answer is I could.
Yeah, you could. Yes, you could do
Okay.
that as part of the road right of way, right? Yes, yes. And so we have this question then of why would we make a distinction between two people using the pipeline and one person using the pipeline? And the courts below get kind of trapped in this idea of public use and then kind of mixing up public use in different contexts that it appears. Public use is important for roads because for all public rights, the only power that the state has to take private property is for a public use. But that does not mean that every member of that only for public utilities. Public utilities have two rights when they place pipelines. They have the right that they pay for by eminent domain, and they have the right that they share with every other member of the public to use the road right of way. If the right to place a pipeline is not in that scope of rights of the road right of way, then they ought to be having to pay for it, just as they do when they put their pipeline anywhere else.
But
But
aren't you just swallowing up the whole meaning of public use?
No, because because the public use requirement, no more than we swallow up the meaning of public use when I allow a public entity to condemn land that it then uses for a parking lot that serves a development that has a public purpose. The legislature has recently said, we're not going to allow those kinds of uses of eminent domain, but the courts didn't say that. Instead, we need to find a nexus to the public. And we have a nexus to the public because of transportation. We have a nexus to the public because of the fact that it reduces traffic. We have a nexus to the public interest because it allows for the recycling and efficient use of water. We have a nexus to the public interest because it allows for agriculture in Kansas to remain competitive and efficient. All of these things are reasons that justify allowing a pipeline in the public right of way. And
Aren't those all questions of fact, though?
no, the question is whether the pipeline easement contains the right for a pipeline for private purposes. And it certainly does, because a pipeline for private purposes by its very nature is transportation. By its very nature, it's taking cargo and moving it just as you would with a truck. And by its very nature, when it makes that subterranean, it's reducing the traffic, just like the telephone pole reduces the number of messengers that need to go down the public highway.
But doesn't a truck that never leaves impede traffic?
Well, it depends. A truck that's out of the way doesn't. And that's the question. What we can't do is we can't impede traffic. If we do, it's not that we're violating the neighbor's rights, but certainly the public can say, you can't do that. You are abusing the right of way because you're blocking traffic. We're not blocking traffic. There's no one who cannot pass through that road because the pipeline is there. And again, if what we end up with is more people want pipelines, then there is space to accommodate them. That is traffic regulation. That's what we do with then why we have traffic lights, why we have restricted access highways, ways of in imposing regulations to better deal with the multiple demands on a limited resource. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.